Your Honor, we have the ability to play his statement back on the body cam through there if we hook up our HDM.
I don't know if you do or not. I'm not a tech guy, so
We've got.
I know if it's done correctly, it'll do it.
Well, when I'm done with questioning, then maybe I can go back and do some impeachment of the statement. Now, isn't it true that when you spoke to the police officer, you stated probably 5 times that your brother brandished the firearm in front of you? That was your statement to him when they were talking to you at the gas station.
Yeah, there'd be the legal term of pulling a gun on somebody's brandishing a firearm.
Okay, but you weren't necessarily saying he pointed it to you. You were saying he brandished it at you.
He brandished it and proceeded to put it in my face.
So was it all in one action, or did he have it out and kind of show you for a
He
while?
pulled his hand like this out of his pocket, gun was in it, pulled out and put it in my face like that. That's
All in
exactly
one-
what happened, all in one motion.
Okay, all right. Now, is your testimony that your brother never told you to leave the restaurant, never told you to leave the residence?
On
After
November
the
4th.
firearm was pulled, he did.
11/4.
Not until after he pulled the firearm.
Okay.
And Judge, I'm gonna ask an answer.
Probably was. Move on.
As soon as you came to the door and spoke to your brother, you inquired if Dad was there, correct?
No, I didn't ask. He asked me what I was doing there. I stated, I'm here to see Dad. That's when he pulled the firearm and said, well, you better get to stepping while you can.
Did you ever receive information as to whether or not your dad was there?
No, because he pulled a firearm, maybe I left. I had a 2-year-old kid in my car.
Your daughter wasn't outside of the car, right?
She was about 10 feet behind me in the car.
Good.
Bullets go through things.
How long is it with you? Remember, we're going to ask play body cam of his statements to the police.
And Judge, I'd object, there's no foundation that's been laid.
Well, all right, fair enough.
That's
We can
fair
do it to the
question.
police officer. We'll just call him and he can identify it as his body cam and all of that.
Okay.
Just a second to make sure I'm either done or not done with this witness. Before you went there, you spoke to your uncle.
Objection, where's there, Judge?
Wait, before you showed up with your daughter at your dad's house, you had a conversation with your uncle, correct?
True.
And
Objection.
He's already answered it.
when you had that conversation, did you feel encouraged to go to your dad's house based on that conversation?
Yes.
And why so?
My uncle never indicated that he thought it would be a bad idea.
Objection, relevance, not just relevance, hearsay. He's testifying to what his uncle said.
I asked him
No,
specific.
he's asking how he felt after the conversation. So that's not hearsay. What's the relevance?
Well, the relevance is what his state of mind would have been going there.
Okay, I think we've already established that he had no concrete reason to feel he would be welcome when he went there.
That's fair enough.
Which doesn't mean he can't still show up and try to
sure.
mend things. So move on.
Sir, you wanted a relationship with your granddaughter, with your grandfather, your daughter with your grandfather. Isn't that true?
Can you repeat that?
You wanted your daughter.
So I need to hear it.
It was important for you, for your daughter to have a relationship with her grandfather.
Yeah,
Isn't that
that's
true?
important in any kid's life.
Well, and you stated today it was important because you didn't have a relationship with your grandfather. Isn't that true?
True.
And you went over there and attempted to facilitate or put together a relationship with your dad and your daughter, correct?
No, I just let it be known, wanted to let it be known if you wanted to be a part of his granddaughter's life, definitely could be an option, something that could happen.
Well, didn't you text him that previous to you showing up, that if he wanted to meet his granddaughter and be a part of his life? Isn't that what you testified to previously?
Yeah. True.
So when you showed up there, you didn't need to show up there in order to get that message across, correct?
True, but he also didn't, I didn't get a response. I didn't know which way,
Next
one way or
question.
the other.
Next question.
I asked you this question. I just want to make sure that I covered it. Your testimony is you were never told to get in the car and leave.
No,
And you were free to leave. You didn't feel like you were a hostage there, were you?
no,
He never made a statement to you he was going to kill you, did he?
indirectly. He said you better get to stepping while you have a chance. I guess it's up to your own interpretation on how to take that, depending on who you are.
Isn't it true, sir? You were upset with your brother for rejecting you when you showed up there with your daughter to meet
No.
his father.
Not true.
You weren't upset.
No,
It didn't affect you that you wanted to have a relationship with your daughter with the grandfather, and you were turned away at the door.
And I'm gonna object, Judge, to relevance.
Relevance is state of mind. And
State of
motive.
mind's relevant. But he's answered the question.
wouldn't,
Is it also true, sir?
no, but I didn't pull a gun on anybody.
Is it also true, sir, that you wanted your brother, but when you spoke to the officer in this case, you specifically told them you were making that report because you wanted your brother to get a reality check, right? Isn't that what you told them?
True, we don't live in the wild, wild west. You can't pull guns on people like that anymore.
I don't have any further questions.
Mr. Muhammad, any redirect?
Mr. Backus, when you approached this location and you were greeted by your brother aiming a firearm to your face, did you have on you any weapons at that moment?
No. Also, there was a
No, there is no also. Last time I'm gonna tell you, you ask, the question is asked, you answer it, and you stop. Next time you do that, I'll just throw you out of my courtroom and hold you in contempt, putting you in jail. Clear?
Clear.
Mr. Backus, please just answer my questions. Now, did you knock at this door or did you enter the room?
I knocked on the door.
Okay. And did you ever enter this location?
Never.
And you mentioned earlier that, the testimony came out that you texted your father wanting to go over. You never got a response.
No, I
correct?
never said I was gonna go over their house or anything. I just said, hey, you have a granddaughter. She would probably enjoy having her grandfather and her wife.
And so my question is, did he ever respond until you know?
No.
Nothing further.
Any recross?
I can't look at, I'd be expanding the record, Judge. I know better.
Okay,
And you've been generous with me, so.
thank you. Mr. Backus, you're free to leave. Watch your steps, sir.
I could like leave or.
Yeah.
Okay. I just wanna make sure.
Any reason for me to stick around?
No.
Okay, yes, you can leave.
Have a good day, Howard.
You as well. Any other witnesses from the people?
Nothing from the people, Judge.
Defense witnesses?
We're calling a witness right now. We're seeing if he's going to come and testify. Uncle Kevin.
Sir, all the way up front, please. Watch your step on the incline ramp, all the way up here. Watch your step on this ramp. Raise your right hand for me, sir. Do you swear or affirm to tell the truth, the whole truth, nothing but the truth? I do. Have a seat right there in that chair. Settle in that chair and state your full name.
Kevin Lee Backus.
Thank you, sir. Mr. Mullen.
Mr. Backus, do you know Dylan Backus?
Yes,
How do you know him?
he's my nephew.
And do you know Joseph Backus?
Yes,
How do you know him?
he's my nephew.
So would it be fair to say you've known them all of your life?
Yes,
All their life, rather, I'm sorry.
yes.
Did you have contact with Joseph Backus on the day that he came over? Let me give you the date, November 4th, 2023, which would be the day that he had an incident. First off, are you aware of an incident between Joseph Backus and Dylan?
I'm addressing Judge Oakley.
I'm asking if he's aware.
I think it's fair. I think it's fair.
Yes,
And how are you aware of that?
because I ran into Joey prior to him going out there.
Okay, and when, prior to him going out there, you had a conversation with him,
Yes, I did.
and during that conversation, did you encourage him to go out there?
Objection, leading.
That's a yes or no. I allow
I'm sorry, can you repeat the
I
question?
said, during that conversation, did you encourage him to go over to his father's house?
No,
Was there anything about his manner that you noticed when you spoke to him that day?
yeah, he came up to me, give me a hug. I could smell liquor on him. I would say my guess is whiskey, smelled like whiskey.
Objection, speculation.
it was.
But
And I just didn't want no confrontation. I gave him a hug back.
And Judge,
What's
I'm also gonna object to relevance. I don't know how, whether he was or he wasn't intoxicated, hypothetically, how is that relevant to the case we have before us?
It's a credibility issue. I'm more concerned with the timing. When was this meeting?
what time did you meet with him?
It was approximately, well, I don't remember the time of
Was it
day
on November
exactly.
4th?
It was on November 4th.
That's all I needed to know.
And, okay,
That's enough. I just wanted to make sure it wasn't 3 weeks before.
gotcha.
Was it before he went to his father's house?
Yes,
Okay, and
Objection, speculation. How's he gonna know that?
He's already answered it. Gotta be quicker.
have you ever seen your nephew, Joey, be physically aggressive prior to November 4th? And if you have, could you give us a time frame?
what timer?
No, a time frame.
Well, over the over the years, me and my brother are 11 months apart. Okay, we grew up, with your fist fights and such. I've seen them boys go back and forth, and Joey usually is more the aggressor than Dylan ever was. Dylan's always been the guy that's, tried to, defend himself against the older brother, in my opinion. I've known him, I've known these kids. Me and my brother were in business together. I used to spend every day after work out there. I think them kids are like my kids. They're very tight.
And just so, and Judge, I know you'll give me the asked and answered if I asked it. Did you encourage Joe to go to his dad's house that day?
No,
Objection, ask an answer.
It was.
All right, I couldn't remember, Judge, and I think that was an important question I had. I don't have any further questions of this witness.
Any questions for this Mr. Backus?
Just a Mr. Backus, you saw Joseph on that day, correct?
yes,
On November 4th. You see Joseph in the courtroom today?
no,
On that day of November 4th, did Joseph have a gun on him or any sort of firearm?
he actually asked me to come see his daughter in the car.
Please just answer my question. It's a yes or no. Did he have a firearm on him on that day? Joseph?
Yes, in the car.
How do you know that? Did you see that weapon?
Yes, he took me back to his car, opened his trunk and showed it to me.
And
And he also had a bow and arrow in the trunk. Hunting gun and a bow and arrow in the trunk of his car.
nothing further.
Just one question. Tell Joey anything about going over there that day?
Did I tell him to go over there?
No, did you tell him anything about going over there that day?
No, that was all his idea.
But did you
I
have,
knew you couldn't do just one question. Go ahead.
did you give him any advice from you about him going over there?
Yes, I told him it was a bad idea.
I don't have any further questions.
Any recross?
Yes, Judge. Mr. Backus, did you ever approach Joseph and tell him to back off from prosecution or try and intimidate him in any way?
No,
Did you ever threaten Mr. Backus with a weapon?
no,
What was Mr. Joseph Backus wearing on that day?
I honestly don't remember.
You said he showed you a bow and arrow. Can you describe that bow and arrow?
Here's a compound bow.
It was a what?
Compound bow for hunting.
Okay, what color was it?
Camouflage, I believe.
Was there any arrows attached to it?
It was in a case with arrows.
What color were those arrows?
I don't remember.
And you said there was a firearm as well, right?
Yes,
What color was that firearm?
I believe it was black stock.
It was what?
Black stock.
What do you mean by stock?
The stock, I believe, was black and the barrel was black. I don't remember the size of the caliber he said it was.
Okay, was
It
there
a hunting gun?
an ammo attached to that gun?
I don't know if there was ammo in it. I didn't ask him if it was loaded
Are you how do you know that it's a firearm and not a BB gun?
because he told me it was his new hunting gun and he wanted to show me his
Oh.
bow.
Okay, you said it's his hunting gear?
He said, yeah, this is my hunting gun.
Okay,
He says this, yeah,
okay, nothing further.
Okay, so you can step down. Watch your step on the right.
thank you.
Thank you for your time. Any other defense witnesses, Mr. Mullins?
We would like to call the officer in the case. We just want to get his name correct. Is it Officer?
I'm gonna suggest it's either Zeismer or Lujovic. I'm not sure if I'm saying it right. Officer, come on, raise your right hand. Swear affirm, tell the truth, the whole truth, nothing but the truth
I
today.
do, Your Honor.
Come on up here, watch my ramp, don't trip up. Settle in the witness chair. After you've settled in, state your full name.
Officer Travis Ziesmer, Your Honor.
Say it again.
Officer Travis Ziesmer.
Ziesmer, thank you.
Yes, Your Honor.
Is it Seasport, right?
Ziesmer, sir.
Officer Seasport, did you respond to a call on the 4th of November 2023?
Yes,
And you had contact with did you have contact with the complainant in that matter, Mr. Joseph Backus?
I did.
And do you recall whether or not you interviewed him at a BP BP gas station in reference to this case.
I did, sir.
And at the time that you interviewed them, did you have a body cam that you were wearing?
I did, sir.
Do you know if that body cam was operating correctly on that day?
To the best of my recollection, yes, sir.
Sure. And if I were to show you a video, would you be able to tell me if that would accurately represent the circumstances of you interviewing Mr. Bacchus at that gas station?
Yes, sir.
And would your body cam have recorded your question and answer? Look, back that question up. You wear a body cam, and when you turn it on, the purpose is to record interactions between witnesses or civilians when you're doing an investigation. Would that be a purpose that you would use it for?
Yes, sir.
And you were using it were you using it for that purpose today? I mean, on the 4th of November?
Yes, sir.
I have it plugged into the HDMI thing that's on the table here. Thank you, Madam Clerk.
Sir, Your Honor, can I ask him another question before we start this?
Sure.
When you interviewed him, did you ask him about describing the firearm that he told you was part of this incident between he and his brother?
I believe so, sir.
That's my background. I don't know why my screen isn't
Yeah,
showing.
it's a lovely background too.
Oh, thank you. It's up in the Keweenaw Peninsula.
Beautiful.
Give me just a moment to check my settings here. I apologize. Your
Try,
Honor.
I was told to hit your desktop and hit display settings and it automatically will start going on. At least that's what we
Oh,
did.
okay. So let's see.
How do you pronounce your partner's name?
My partner's name? Walovich?
Walovich?
Yes, if that's what
That's
it's.
pretty easy.
Yeah, if that's the one.
It's a lot easier than spelled.
Yes, okay, so yeah.
Heather, Walovich.
Judge, is it okay if I take 1 minute to back it? While they set up-
Yeah, while we're doing the tech stuff, sure.
Okay, there we go.
Do it quick. Spell it. Ziesmer. See, I would pronounce yours Zeiss.
Ziesmer.
Yeah, I would have said Zeiss with the IE.
I get it all kind of used.
Oh, I bet you did it butchered really well. Not as bad as your partner.
Oh, no.
Yeah, those J's completely throw you off with his name.
I play just a moment just to make sure the sound's coming through too. Okay.
Knock
Thank you,
yourself
Judge.
out.
Oh, it's coming through my laptop, so there is an issue with it.
Mr. Jerome, if I understand correctly, really all we're after is the audio on this.
Yes.
Push comes to shove, we can probably just play your laptop next to the microphone.
Okay, thank you, Your Honor. I think it's something with my settings where I think I just have to click this button and I think this is gonna fix it. Yep, okay, there we go. My apologies, Your Honor. Thank
No problem. I love me some technology.
you. It's great until it isn't, you
And
know?
that was all pure sarcasm, just in case you missed it.
Didn't miss it.
All right, we're back on the record, fellas. Ready to start the video?
Yes.
Just play.
Yep.
She said it was black and silver, some black slide. Okay, looked like a roofer.
this out. Was that the complainant is better describing the firearm?
It was, sir.
And officer, at any time did you recover a firearm that was alleged to be used in this incident?
Yes, sir.
If I were to show you a picture, would you be able to tell me if that was the firearm that was recovered?
Yes, sir.
Is that the firearm that was covered,
Yes, sir, it is.
recovered?
Yes, sir.
You got that picture, right?
Anything else at this point?
No further questions.
Officer, this weapon that was recovered, who did you recover it from?
Who did I recover it from?
Yeah,
We got it from Dylan.
and is Dylan in the courtroom today?
Yes, sir.
Can you please point to that individual, print out an article that individual for wearing?
In the gray shirt on the far
Your
right.
Honor, let the record reflect.
Noted.
Witness police officer has identified the defendant. Where
Noted.
on his body did you recover this firearm?
He actually didn't have it on his body at the time.
Okay, where was it recovered?
It was actually in his room
In
as
his
he,
room?
yes, sir.
Was this weapon loaded?
That I don't know.
What did you do with this weapon?
The weapon was entered into evidence.
Okay, did you make the weapon safe prior?
I didn't enter it into.
All right, nothing further from this witness.
Any redirect with the officer?
No, Your Honor.
All right, thank you, officer.
Thank you, sir.
Watch your step.
Oh.
Can we send him back to wherever he'd rather be?
He can go back.
Yeah, you don't need him to stick around?
My only question is this, Judge, it's different because we're doing evidence. I would like to admit both the video and the picture.
We don't need him for that discussion.
No, but I mean, but we did it by video, you know what I'm saying? I
Right.
don't have something tangible.
Right.
Do you have an objection to that?
So I would just request that what's been shown is okay to be admitted, but I don't know what else.
Okay, all right, that's
For
perfect.
that time.
That's fine. I'm not asking something you didn't see. That's, I appreciate it.
Admitted. So is Officer,
The OIC is free to leave.
how about Officer Olovich?
Any officer?
The other officer was there.
Yes.
You guys have a nice day.
Thank you, Your
Stay
Honor.
safe.
For clarity of the record, Brad, you should-
All right, any other witnesses from the defense, Mr. Mullins?
No more witnesses, Your Honor.
All right, any rebuttal?
Nothing, Judge.
All right, so I'm ready for argument, guys.
Judge, the people moved to find over on all counts. The testimony today by Mr. Joseph Backus is he went to go see his dad. He texted him, sure. His dad never told him he's not welcome.
Let me stop you. I heard the testimony. I don't need you to recap it. If we have a 3-day exam, that'll be helpful, but after this short one, I don't need it. Any argument, I'll let him respond to the argument.
Your Honor, I'm gonna talk case law. Case law as far as a preliminary exam, what this judge, what this court can consider in determining a bind over. Now, often, Your Honor, the court doesn't look at affirmative defenses and other things, because there could be questions of fact. What could lead the court to say, hey, that's for a trier of fact, and not necessarily for this court. But there are exceptions. And under the People versus Robert Redden, 290 Mishap 65-8485, and People, and they were quoting People versus Woltening, which is 272 Mishap 678 690. The court noted that in situations in which a defense is complete and there's no conflicting facts regarding the defense, it can be argued that there's no probable cause to believe that a crime was committed. Now, I'm asking the court to do a lot. Now I'm going to backtrack and tell the court or explain why I think that's relevant here. People versus Johnson in 2020 gave an opinion. Oh, I'm so sorry, Your Honor. I'm reading you the wrong case law. I got a specific case law. As I'm looking at use of force and what's allowed for an individual in a situation on their property. And I'm going to explain the facts and give the case. In this particular case, an individual pointed a gun at someone's face. And the trial court ruled that pointing a gun in someone's face was considered deadly force. Now, when you have deadly force that you use, you have a different requirement to show as the defendant in order to get the affirmative defense. And in fact, when you have deadly force, that you use in an instance, that would be considered, you have to have a situation where deadly force is necessary and you're saving, your life is at risk. It's a risk of your life in order to do that. But the court in People versus Oakley, which is a 2022 case, 341, Mishap 28 says, pointing a gun at someone without more is not deadly force. It would be different if you pointed the gun and fired it and said, shoot. I was shocked when I read this, Judge, because I've been doing this a long time, and I would think clearly if you point a gun at somebody, that's going to be deadly force. The court specifically indicated that putting a gun and pointing at them in of itself, that's not deadly force. So in this particular case, if we are following the case law, Mr. Vargas did not use deadly force when he encountered his brother, even if you agree with his brother's story that he pointed the gun at him. And I've got questions with that. And the reason being is, you saw the evidence. He described a totally different weapon that was used. That weapon that the police recovered, and the weapon that was alleged to have been used in this, had a desert storm color, totally different than the gun he described. We also heard the witness fight with the lawyer, kind of be flippant about different questions. We know he did not have a good relationship. We know he wasn't in contact. We know he reached out to his dad for his own testimony, and nobody gave him permission. He wasn't welcome. He left over 2 years ago with a dispute with the family. We heard testimony of his uncle that talked about the relationship between the two brothers and how the older brother was a little more of a hothead and the older brother would get the better of his younger brother, which is not unusual in a family. But this goes to the state of mind of my client, when now, over 2 years later, his brother who's been removed from the place shows up and is there on his porch. And now his brother wants to see dad. Well, based on the relationship, it's the individual who is not engaged in using deadly force. It's a different standard. If this person reasonably believes that the use of some force is necessary to defend himself against that individual, they would be justified in it. I think the facts in this case kind of line up that way. You got an individual, all the things I told you about him. And furthermore, I don't think he misidentified the gun. He said it was right there. What do you say, 6 inches from him, a couple feet from him? I think the witness was not a credible witness. And in a preliminary exam, you're sitting as trier of fact and trier of the law, and you can make a credibility consideration. My client is at his home. He has no duty to retreat. And when he's faced with a threat of his brother, and I think the evidence is pretty much square on. And I'm asking for a lot, but this is one of the rare cases where I think the stars line up and the facts line up, where he doesn't have to show he was facing deadly force. Even if he's wrong in his belief, but it's reasonable for him to believe that his brother's a threat, then I think that's enough for him to use not deadly force to remove what could be considered a trespasser at that point. And so I ask you to clarify.
Thank you.
And so, the charges in this case are felonious assault and weapons felony firearm. I mean, that was a great speech on the use of intent to use deadly force, but that's not a requirement for the elements.
It was a great speech. It was a great speech.
It was, without question, if it was regarding the intent of using deadly force. But unfortunately, for brother counsel, that's not the elements for the crime. So the elements in this crime are make an assault with a dangerous weapon, but without intending to commit the crime of murder or inflict great bodily harm less than the crime of murder. So the weapon that was used in this scenario was a firearm. It was recovered by one of the officers. The testimony by the OIC today was that this firearm was recovered from the defendant's bedroom. The testimony today reflects that this weapon was used and aimed at the face of the victim. And the victim stated that he felt in fear. He panicked. He had to leave the situation. And that's what he did. Nothing on the record indicates a self-defense kind of claim where the victim approached the defendant with a weapon. He stated he wasn't armed, he had no knife, nothing. So I believe without question, probable cause, the standard of probable cause has been met in regards to these two elements, and we're gonna move to bind over on these two charges.
Thank you, John.
Judge, and
Go ahead, I'll give you a shot.
Super brief. I think the important thing to bring out is, this goes to an affirmative defense that my client has. It's not necessarily, we're going through the elements of it, we're talking about an affirmative defense. In the case law that I cited, People versus Robert Redden from 2010, published case of the Court of Appeals, allows you to raise a affirmative defense at preliminary exam. Typically, affirmative defenses would be raised at trial. I know that. But that case specifically says you can do so. And in doing so, you can consider the credibility of the witness and whether or not it's reasonable for my client to feel threatened by this individual. You heard the facts, and I'm not going to repeat all the facts of the relationship. As I relate to the gun, that's the gun that's alleged to be used. That's not the gun that was identified by the witness. Again, going to his credibility of whether or not this crime really was committed. And what they say is this: if the affirmative defense has the issue, if the elements of the affirmative defense are met, this court can find that probable cause that a crime occurred did not happen. Because that's one of the things, whether he committed a crime, and by probable cause, the elements of the crime have been present. So for those are the reasons why I think it's appropriate for you to quash bind over in this particular case.
Judge, I'll be very, very brief, I promise. I don't know what the affirmative defense is for. This victim went to the home of his father to show his father his newborn child. He didn't go there with a gun. He knocked on the door, he left. They didn't want him, he left. That's all that happened here. It's a sad case that a brother is pulling out a gun and aiming it at his brother for wanting to, his older brother show the family his newborn child. I think this is a very, very sad case, and it's sad to see that it happened, and we're still moving to bind over because the elements of the crimes have been met. Thank you.
Thank you both. The trier of fact. The testimony was that there was more than pointing a gun. There was get to stepping while you still can. That's a threat. And I'm a huge stand your ground, all that, but you don't open your door and point a gun at somebody. There's got to be something to precipitate it. If you ask them to leave and they refuse, if they make threatening gestures, whole different ballgame. The testimony today was there was no conversation. He was not asked to leave. The gun came out and get to stepping. This is a trier of fact issue. So I'm going to send it downtown. Your next court date's going to be February 14th at 9 a.m.
February 14th?
14th, yeah, 9 a.m. Bond will be continued unless I hear something quick. Bond will be continued. Wish you luck downtown, sir.
Just one last thing, those two exhibits, will they go with it?
I don't know how we're going to do that because, yeah, we don't.
The record marks those two exhibits, the video that dealt with that short interview with the brother regarding the description of the guns, as well as the,
Yeah.
No, thank you, I appreciate it.
Yeah, we can do that. Right, picture of the gun, just put in the notes that images were shown and admitted. Which one are you going to do next, Mr. Mohammed?
I think Michelle Japanga, can I just go check?
Yeah, we've got her on Zoom. She's been here for quite a while. Gentlemen, you don't have to go far, but you got to get out of here. Good luck, Don. Good luck, Don.
I still have one more, Your Honor. Hopefully, he's not going to pull my deal now. No, I'm joking. I'm
Mr.
teasing.
Mullins, I was informed that the exhibits are for this exam only. So when you go downtown, we'll probably be
Oh, look, no problem. It's just, I'll file a motion to quash bind over. I want to use that. You can only use the lower record.
Shannon.
As long as they're not part of this record, that's all that.
Does that mean what? I can't do that. I don't have video. I can't. The only thing I do is I
Hold on, hold on, turn
transcribe
yourself
it.
in. You gotta
No,
watch
no, that's all I need.
No, no.
I'll make the rest of the
Much
argument.
money and he hadn't done anything that was supposed to be corporation wants.
So you just came in today?
Yes, yes.
Okay.
And Al saw him this morning.
Okay.
Some morning sent it to me.
Good.
And once he was done, with all the information for the community service over to the commission, they have shelter for him.
Really?
Yes. It's intent.
Yeah,
So my thing was
it's
checking
shelter
with you.
now?
Yeah,
Yeah. do
my
it.
was check with you.
Do it.
to See if we can, I can drop him
Fine.
off, take,
Sure. I don't think you should go alone
huh? Yeah, I'll take this then.
Yeah, yeah.
Okay.
though. Yeah, take him. Great.
Good,
Perfect.
just wanted to clear it out, check,
Yeah,
I'll
no,
let
we
Mariah
get-
know as well.
We just build goodwill with him. Now maybe we can close our files out with the community service.
Yeah.
Yeah,
Just wanted to make sure.
Yeah, be careful. Yeah, thank you. Yeah. Yeah. Wise guy. It's the black shirt. Yeah. All right, gentlemen, appearances for the people versus Michelle Japanga.
Good afternoon, Your Honor. Mohammed on behalf of the people, PA 6771.
Good afternoon, Judge Oakley. Good afternoon to your staff, Neighborhood Defender Service, Carrie Martin, P 84592. I appear on behalf of Miss Michelle Japanga, who appears by Zoom. Ms. Japanga, state your full name.
Michelle Renee Devon.
Thank you, ma'am. She's still in treatment, I assume?
Your Honor, I had Ms. Japanga Zoom in today because right before I got a call from her around 11:30 and from her boyfriend, actually first from her boyfriend, that she had a seizure. So she's an epileptic and you had previously granted her permission to appear by Zoom
Right.
because of her epilepsy. She cannot drive. She had another seizure just today. Heard it from her as well. I didn't want to jeopardize her health in any way. And I had also heard from Detective Rice that an officer who I believe to be a necessary witness in this exam, that would be former Officer Kilgore of formerly of Brown Millis PD, is not present. So I am, for those and other reasons, if you'd like me to put them on the record, asking for a dismissal.
Is that a no? She's not in treatment?
She's not in treatment.
Okay, all right. Yeah, you're gonna have to give me more than she's had a seizure and they've got one missing witness. What other reasons do I have for dismissal?
Well, Your Honor, the missing witness is the officer who, in this incident, which was November 2021, who first approached Ms. Japanga, found her overdosing. That's a critical issue for exam because that would, under the statute, show you, that would make it that she had not committed this offense. Now, the only officer that we have is an officer who arrived later after this had occurred. In addition, we don't have body cam. And I had Judge Martin sign a discovery order requiring that they produce body cam depicting the interactions with Ms. Japanga. I was provided some other forms of digital discovery, but was informed, Mr. Mohammed showed me a communication from the OIC. I'm not sure whether it was Detective Rice or the previous OIC on this case, that body cam no longer existed.
All right, so the initial contact between her and, was it Kilgore?
Kilgore.
That we don't have that video.
We don't have that video
Okay.
and we don't have Kilgore.
Okay, okay. All right, response?
Judge, we did, after that discovery order, from what I recall, my computer's down at the moment, but I do recall us sending some digital discovery that we got. And as Mr. Martin disclosed, some stuff just didn't last over time. I think this is a couple years back. We are ready to move forward today. We do have Officer Dorsey. I understand Ms. Japanga suffered seizure in regards to that, but we are prepared to move forward today. We are missing one officer that does play an important role, and so we would request the help in part in regards to that officer.
Okay.
And
Is there, hold on a minute. Am I safe to assume that you don't have any civilian witnesses, just law
No,
enforcement?
police officers.
All right, so number one, she just had a seizure. Number two, you want Kilgore. I'm assuming you don't know if you can get him or not.
Yeah.
Do we know?
he works down in Auburn Hills, we're able to get a hold of him, this subpoena came in late, so he is available,
Okay.
we weren't able at the time to get him
Okay,
for this day.
all right.
And just for the record.
So hold on, I don't want to start it and finish it later. That's selfishly, it's just rougher on me. I also think that it's not probably the most compassionate way to handle it for Mr. Penga. I'm inclined to adjourn.
Your Honor, I would respectfully renew a request for dismissal, not just because of the missing witness, but because of what I'm saying is a discovery violation that will prejudice Ms. Japenga if this case were to go forward.
But if I understand correctly, you've got everything they've got. They just don't have what you want.
Well, what we have is a concession from the people that this body cam footage previously existed and they allowed it to be erased, destroyed. That is a Youngblood violation. That's a due process violation. That is, they once had access, control of possibly exculpatory evidence, and they failed to preserve that evidence.
Yeah, but I also, and I'll give you a chance to argue it, but I also think there's got to be a bad faith before the result is a dismissal.
Youngblood does require bad faith. Bad faith can arise from blanketly, maintaining a system that erases discovery, including on pending cases. I mean, this isn't just, our old closed cases. We can say, it was just a technology failure. But at the end of the day, if you have a police department that is knowingly or that knows that footage from pending cases is getting erased and destroyed, I would argue that's enough for bad faith for Youngblood. And even if you don't need Youngblood, I would argue it's a Brady violation, which doesn't require bad faith, where you had possibly exculpatory or at least impeachment evidence that was in the possession of the people that has not been provided.
All right, so let me ask you this. What do you think the video is going to show that helps her?
I think the video would show that the police officers who responded were responding to what appeared to be a drug overdose and what I actually believe was a drug overdose.
Right. That
under the statute, I've got it right here. Basically all the sections of the Controlled Substance Act, including the one she's charged under, which is 333-7403, contain a subsection 3, which states that an individual who requires medical assistance and is presented for assistance by another individual, if he or she is incapacitated because of a drug overdose or other perceived medical emergency arising from the use of controlled substance, and possessed an amount sufficient only for personal use, and this evidence of the violation is obtained as a result of the individual seeking or being presented for medical assistance, that individual is not in violation of the section.
Okay.
Now, I would say that.
Hold on, I'm with you. So is it the people's position that she was not suffering effects of an overdose at the time of the interaction?
I think that is the people's position, is that there was a response for a 911 call. The officers responded, they made contact with the defendant, and in plain view, they did observe drugs, which were the suspected cocaine.
But she was conscious, she was interacting.
She was conscious, and it was her own words that it was cocaine.
If I could.
Yeah. I just want to make sure I know what their position
The
is.
nature of the 911 call was an unconscious female.
Okay.
When, according to the report, when Officer Kilgore responded, Ms. Japenga was unconscious. He performed a sternum rub on her. And though that did arise her, she was later, nodding off again.
Right.
And Judge, just for the record, I'm pretty sure the person who did that 911 call was her friend. And I don't know if that helps.
I don't think that matters under the statute.
I just want to make sure I'm disclosing.
I think the determinative factor in the statute is her condition at the time of the initial interaction. Would we all agree on that?
Yeah.
Okay.
I'm with you.
Okay. I'm not going to dismiss it at this point. Here's why. if Kilgore's testimony is all of what you just told me, I think then that's the argument.
Yes,
She was in the midst of an overdose at the initial interaction,
yes,
which then I think triggers subsection 3.
yes.
I don't need a body cam. If he says, no, I got there, she was talking, it was fine, you know, blah, 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 then you can renew your motion because, yeah, I think at that point, the body cam could impeach that testimony.
Well, for purposes of today's argument, given that the people did not subpoena Officer Kilgore, would you entertain looking at the reports in which Officer Kilgore does state that he found Ms. Chapinga unconscious?
And I'm gonna object to that misrepresentation Mr. Carey is making to the court and for the record. Subpoenas were sent weeks in advance.
Oh, no, don't even go there because I'm not think he's trying to. I don't think he's trying to paint you in a bad light. He's saying we don't have the cop, but we've got his record. Can we just go forward with his reports? Any objection to that? I mean, I'm okay with an adjournment if you want to get Kilgore here, but if you want to save the time and just go on his reports, from what Mr. Carey just told me, the reports make the argument. I mean, I haven't seen the reports, obviously.
Yes, and I would need to grab my computer and pull them up, but I can do it in about 30 seconds.
I feel strongly both ways, so.
So, Officer Kilgore does state that he performed a sternum rub to wake Miss Michelle Chapinga. Chapinga woke up and when asked what she had taken, and that's when she made the statement that it was possibly cocaine. And that's a representation I want to make to the court.
Okay.
And I'll, live by your decision.
Well, I think we can all agree if he's doing the sternum rub, it must be because she was non-responsive when he first approached her.
Agreed.
I'm dismissing it.
Thank you, Judge.
And you guys can build the record. You can take the dismissal because the discovery violation, because of section 3. I think we could have a full-blown exam. I'm going to be the same place.
Yeah, I think section 3 doesn't apply.
All right.
Thank you.
Okay. Ms. Chapinga,
Yes.
you're all set. Case dismissed.
I'll call her.
I'm going to write it up as dismissed after exam. Just because I don't think it matters too much, but that's why I'm going to write it up.
Works for me, Judge. Thank you very much.
Good luck, ma'am.
Your Honor, thank you very much.
Thanks, guys. We still got a couple files, don't we? What else do we have?
The next one is Michelle. And then we have, Michelle was the first to 12:30.
Hey, Joe.
Yeah.
On the way out there, find out if we're ready on Miss Shaw.
Michelle?
Yep. Go ahead.
I appreciate it. Yeah. I think that's the right choice.
What's next?
Your Honor, everything.
You as well. Stay safe. Mohammed, are you doing Michelle too?
Yeah. Judge, that last one, that drug one with, it's a codependent one. I'm gonna need a minute to talk to officers. It's kind of a big case.
What's the name?
Um,
Michelle, you mean? Or
no, it's Stacy Jackson
Okay.
and Dwight Jackson.
can we,
I'm sorry.
you want to talk before you get to Michelle?
Yeah,
Go ahead.
I'm just sorry because I didn't anticipate that FA to be.
No, that's all right.
We're rating pretty good. You have a lot of files up there?
Yeah, I've got Shaw, I've got Crenshaw, and then I've got some of those are probably no shows.
So that Sarah Fournier, no show. What?
What's that? Oh, you did, yeah. Yeah, for an off-the-cuff argument? Yeah, you did a great job. Both of them. Yeah, tell him that. I agree.
I absolutely will.
No, that's a do-gooder thing. I think in certain circumstances, absolutely. Yeah. I'm going to John. Says he had another file, but I don't know which pen it is.